We've all heard stories about HOAs, right? But what happens when homeowners decide to fight back? Well, we're about to dive into a wild case, a real David versus Goliath showdown that went from a neighborhood squabble all the way to a formal hearing. And it all started with a single piece of paper and one very important number.
And that number is 305. 305, that's how many signatures homeowners managed to collect on a petition to recall four members of their HOA board. I mean, that's not just a handful of disgruntled neighbors. That's a serious chunk of the community demanding a change.
So here's the big question, right? If you have over 300 homeowners signing a petition, you'd think holding a new election would be a no-brainer. But that's not what happened. Not even close. So why? Why would an HOA board just refuse to hold an election? What was going on here?
All right, so enter our main character, a homeowner named Mike Sawyer. He wasn't going to let this go. He's the one who stepped up and filed a formal complaint. He basically said, hey, the Terramar HOA is illegally ignoring this petition, and we're not having it. He wasn't just venting online, he was actually taking them to court to force their hand.
Okay, so you'd think the HOA might try to smooth things over, right? Nope. They came out swinging. They didn't just reject the petition. They went on a full-blown offensive. They came back with this long list of reasons why it was supposedly invalid, claiming it was just full of legal problems. It wasn't just a no, it was an attack on the entire effort.
And we're not talking about small stuff like messy handwriting. The board, led by its president, Ben Dass, and another member, Dr. Keith Miller, leveled some major accusations. We're talking claims of forged signatures, signatures from renters who shouldn't have been signing, and even signatures from people who weren't allowed to vote. They were literally accusing their own neighbors of committing fraud. This got serious fast.
So everything ends up in this formal administrative hearing. And the biggest, most explosive claim the HOA put front and center, the one they built their whole case around, outright forgery.
And they thought they had a slam dunk. The board members get up and testify that they personally talked to one of the homeowners, a guy named Mr. Flater, and they claim he told them directly, I did not sign that petition. I mean, that sounds pretty damning, right? Kind of like a smoking gun.
But hold on, because then the other side gets their turn, and this is where it gets really juicy. It's a classic he said situation. On the HOA side, you have their testimony about what Mr. Flater supposedly told them. It's secondhand info. But on the petitioner's side, they bring in a witness, a Mr. Rick Card, who gets under oath and says, no, I was there. I saw Mr. Flater sign it with my own 2 eyes.
The HOA keeps trying to build its case, though. Another board member, that Dr. Keith Miller we mentioned, gets up to testify. He starts listing all the things that made him suspicious. You know, things like misspelled street names, some entries that he thought looked like they were written by the same person, and, get this, signatures that were all in the same color of ink.
And this is where the wheels just completely fall off the HOA's argument. The judge points out something pretty obvious, actually, a huge flaw in his logic. Dr. Miller admitted he'd only ever looked at photocopies of the petition. I mean, think about it. Of course the ink is going to look the same on a black and white copy. That one little detail just blew a massive hole in the board's credibility. Okay, so you've got these 2 totally different stories. How on earth does a judge figure out who's telling the truth? Well, it all boils down to a really important legal idea.
And that idea is called the burden of proof. It's actually a pretty simple concept. If you're the one making the claim, if you're the one doing the accusing, it's on you to prove it. You can't just say something is true and expect everyone to take your word for it. You got to bring the receipts, you know?
Let's break it down. It's super simple. Step 1, you make an assertion. In this case, the HOA says, these signatures are fakes. Okay, but then comes the crucial part. Step 2, you have to provide the proof. You have to say, and here's how we know. Without that second step, the first step is just noise. It's just an empty accusation.
And this is the perfect snapshot of exactly why the HOA's entire case just crumbled. Look at this. For every single one of their huge claims, forged signatures, invalid renters, you name it, what did they provide at the hearing? Nothing. Zero. No names, no specific addresses, no results from a handwriting expert. They even mentioned they did a handwriting analysis, but then never showed the results. They completely and totally failed to meet their burden of proof.
So you have these big, dramatic claims on one side and a whole lot of nothing on the other. The judges heard it all, and now it's time for the final verdict.
And the ruling was crystal clear. The judge found that the HOA had not met its burden of proof, not for any of its claims. That whole elaborate case they tried to build, the judge basically said it was built on sand, no real factual foundation to back it up.
So what does that mean? It means we have a clear winner. The judge declared Mr. Mike Sawyer, the homeowner who started this whole thing, the official winner of the case.
And it gets better. The judge also ordered the HOA to pay Mr. Sawyer back his filing fee, $550. So not only did the board lose, they had to pay for the privilege of losing a case they probably shouldn't have thought in the first place.
But here's the real kicker, the most important part of the whole ruling. The judge gave the HOA 30 days. 30 days to do what they should have done months ago, hold the recall election that 305 of their own residents had asked for.
When you boil it all down, this whole story is more than just a fight with an HOA. It's a fantastic lesson in the power of evidence. And it leaves us with one final thought, something to really chew on. In any argument, what's actually more powerful, making a really loud claim or having the quiet proof to back it up?